understands the intense interest over this.
I thought that was effective lawyering by Mr. Nelson. The defense attorney acknowledged that this case has traumatized the nation, but also inspired an important debate about policing. And he also accurately stated that whatever sentence the judge imposes will be seen by some as too light and some as too harsh. Interestingly, Lester, he essentially testified for his client, saying that Mr. Chauven constantly asked himself.
Thank you for joining us. My name is Nicholas Lamar Soutter. Welcome to Overtime. We are looking right now at the Derek Chauven is expected back in court. The judge has taken a few minutes off to consider his decision. Chauven has, in fact, been convicted of multiple counts of murder, first and second degree, I believe, or second and third, I believe. His attorney has come up and said that the extenuating circumstances, as have been reported by the prosecution, cannot be taken into account because that is already taken into account by the very nature of murder. And the sentencing guidelines for murder are what they are, and that they should not be exacerbated just because of people's feelings that for some reason this is worse. The prosecution has said that this is in fact much worse than just sort of your regular murder, that he abused his position as a police officer, that Chauven obviously was essentially tortured, was begging for his life as he died, and there was a callous disregard. Chauven came out briefly and said that he couldn't really speak much because of pending litigation, but at some point the family would have something that would help alleviate their suffering. We don't know what that means. The judge has asked for, or has said he's going to take 15 minutes to consider what he's heard and to write out the judgment, and then to come back and tell us all what it is. We are still setting up here. I apologize. So I'm going to finish doing that, and we're going to put the audio back on, and we're going to try to sort of collate the information we have and maybe see if we can get a guest to join us. So with that, let's put the audio back on and see where we stand.
With their cell phones out, waiting and hoping, they say, for a just verdict of 30 years, something they say will send a message to the nation.
Megan Fitzgerald in George Floyd Square for us as we all wait. Judge Cahill still in chambers right now. We expect to see him again shortly, and this sentencing will go forward. I want to bring in NBC legal analyst Danny Cevallos. Danny, I want to get your thoughts, but especially on hearing from former Officer Chauvin's mother. What effect that may or may not have in your view.
It was definitely a very sympathetic moment for Derek Chauvin's mother, but it may not have played well with the judge, because sentencing judges don't want to hear someone get up and say how this sentencing will hurt me. I'm going to lose out because I'm losing a son. That's the kind of thing that judges might not take the right way, because it's really about either remorse or the harm that was done to the victim. So while I have all kinds of sympathy for Derek Chauvin's mom, and look, it's hard to get up there, and this is probably the hardest speaking moment of her life. For Derek Chauvin, the defense probably hopes that she didn't push the judge to think that, oh, this is just about my loss of my son, and how my son's life has changed and how my life has changed. Sentencing is really, really a challenging time for both sides. But as defense counsel, it's your duty to put every speck of information out there that may help your client that the judge would allow in.
Danny, thank you very much. We'll ask you to continue standing by as we stand by and await the return of the judge and for this sentencing to go forward. We do want to note that we did hear from a former Officer Chauven near the end. First time we've heard any substantial words from him. Even so, he was a bit guarded, seeming to be acknowledging an appeals process. But here's what he said in the court.
Thank you, Your Honor. At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time. But very briefly, though, I do want to give my condolences to the Floyd family. There's going to be some other information in the future that would be of interest, and I hope things will give you some peace of mind. Thank you.
And again, Derek Chauven in the courtroom just a few minutes ago before the judge retired to consider what he's heard this early part of the day and announce his final sentence against Chauven. We want to go to Jonathan Capehart now, opinion writer for the Washington Post, host of MSNBC's The Sunday Show with Jonathan Capehart. He joins us now. What are your thoughts on what we heard from Chauven and his offer of condolences to the family?
Well, one, Lester, it was interesting to hear his voice since he did not take the stand in his own defense during his trial. I found it interesting that he not only expressed his condolences to the Floyd family, but looked at them to express those condolences. The cryptic nature of this new information that he says he believes will give the Floyd family, quote, peace of mind, I'm curious to know what that is, because given the impact statements from the two Floyd nephew and the two brothers, I don't see what could possibly come out that would bring them any kind of peace of mind. I believe it was Philonis Floyd who said, quote, my family and I have been handed a life sentence, which I found interesting, especially after Derek Chauvin's mother, Carolyn Palenti, said in her statement, when you sentence to the judge, when you sentence my son, you will be sentencing me. These are very powerful moments in the courtroom where you get to hear definitely the victim statements, but I wasn't expecting to hear from Derek Chauvin's mother. And so I am actually very curious to see how this plays out, especially given what Danny just said about how that might impact the judge. A very, very powerful hour or so that we've been watching, Lester.
And as you know, Jonathan, this has been seen broadly as a watershed moment in the whole issue of race and policing. But once again, Mr. Blackwell at the beginning, for the prosecution making the point that this was not about policing. This was about one bad officer who ended up murdering someone he was trying to take into custody. So how should we be viewing whatever happens here today?
Well, I mean, I understand what the prosecution was trying to do, trying to make this a very discreet case and have it be on the facts on the ground, following the evidence and keeping the trial focused, keeping the witnesses focused, keeping the judge focused and the jury focused and not distracted by all of the other.
Community and the family, like no matter what happens throughout the entire process.
And I think as my colleague, photojournalist Bill Angelucci kind of
All right, apologies there. So we are waiting now at this point for the judge to return in the trial. Thank you both. Yep, got it. Thank you for the notification. We're waiting for the judge to return. The prosecution and defense have each given their reasoning for what he should get as a sentence. He could get anything from, as I understand it, from probation to a number of 20 or 30-year sentences to run concurrently. He is... Let me just check one other thing here. Hopefully I'm no longer muted. You guys can tell me. I can't even see the live chat right now, so I should probably check on that. If I don't get another, well, let's just wait. Okay. So he could get any of those things. There were some arguments made on either side. Also, earlier today, there was a hearing on dismissing the charges, or sorry, dismissing the conviction on the grounds that one of the jurors lied on his application for being a jury. He lied when he said that he had not participated in the Black Lives Matter movement, in any of the protests, and or had not followed the case or formed any opinions on it. He had was photographed with a T-shirt. It was a Black Lives Matter T-shirt. I believe it said "I can't breathe," which is an obvious reference to the case. It is clear that the juror lied. It is clear that the juror was involved in at least some of the protests. So the question is that enough to dismiss the charges against him? I have no doubt in my mind Chauven is guilty. I think this is absolutely horrendous, and I think the trial was extraordinarily important. Thank you. Appreciate it, Dorito. So given that, I also believe in the Constitution and there is another case that I was thinking about earlier today for these precise reasons. I'm not sure if I want to get into it. It's actually a brutal case, but it brings into sharp contrast our own values and what happens when they are in conflict and when we have someone we know is guilty, but there have been serious violations. Well, there have been fundamental violations, I should say, in their conviction. So, and they are absolutely irrefutably dangerous fucking people. So I may get into that later. We'll see. Nonetheless, it's clear that this was a violation of, and we have him back. Anyways, I had expected that this would result in a mistrial. It did not. I'm ambivalent about that, but let's hear what we have to say now.
Both from the Floyd family and the defendant's family. I've read all the impact statements that were submitted earlier and listened carefully to all the input here today. And it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law. But my comments are actually going to be very brief because most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case. What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever because it's not the appropriate time. I'm not basing my sentence also on public opinion. I'm not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases. And so, Mr. Chauven, as to count 1, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentence for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense? No, Your Honor. All right. Thank you. We are adjourned.
The judge not reading his full sentencing memorandum and getting virtually right to the sentencing and sentencing Derek Chauven, the former Minneapolis police officer, to 22 and a half years in prison. That is less than the maximum, but certainly far more than Chauven and his attorneys were asking.
All right, so they just said 22 and a half. By my math, that was actually 35 years. It was 270 plus 150. Those were the two. It was the 270 was over the 150, but maybe it included the 150. So that may be why my math was wrong. I got 35. They're saying 22 and a half, I think is what they said.
It's quiet, people kind of taking it all in, waiting to kind of process, and I'm trying to listen for some reaction now, but the young woman we just spoke with a short time ago, Athena, you were just listening to it, so 22 and a half years the sentence handed down to Derek Chauven. That is 10 years more than the recommended guidelines. You just heard what the judge had to say. What's your immediate reaction?
I'm taking this as a win for my community right now. We needed this. It could have gone just so far left that there was no coming back. He said, that he's not doing this, for the public, but he knew he really, really had to. It just had to be done this way, and I'm really thankful, so thankful for my community in the world and just showing that we can't go on like this. But I also take a second back to think about all of the other people this has happened to with the knee on the neck since George Floyd. So I'm taking it as this is a small victory right now, and I'm just so appreciative. But it's going to take me a second to process it and be like, okay, you have 22 years for him. Now let's move forward with who has continued to do this after.
All right, so yeah. So the judge said it was 270 over the 150. I took that to mean over as in the 150, in addition to the 150. But so that would have been 350. Or no, sorry, 3. Well, it doesn't matter. So that was an error. What he meant was 270 over the 150, meaning the 150 being the actual recommendation. He was giving 270, and that comes out to 22 and a half years. So he's facing 22 and a half years credit for time served, which is whatever the time is really on the trial. So That's how much? So it's not quite double the recommendation, but it's significantly over the recommendation. Let's hear what they're saying now.
Trying to make the calculation here again to 22 and a half years. But, sir, the situation here, the sentence just handed down 22 and a half years. We just spoke with this gentleman from Chicago. What's your reaction?
Guilty was served. I don't think that that's enough time to send the message that needs to be sent to say that justice is trying to work for people of color. It's a dent, but we still feel empty today. We feel empty because it still feels like twisted justice in which we're all so accustomed to, but we did get a guilty and then we did get time, but we just feel void today. It still feels void.
Thank you very much, sir. So, Lester, again, some conflicting feelings here. Some folks, you may be able to hear somebody behind me. There's a bit of anger here that they wanted more. Certainly, many people in this community, they had wanted the maximum, up to 40 years. Legal experts, of course, said that wasn't likely. Prosecutors asked for 30 years. So, again, 22 and a half years for Derek Chauvin on that second-degree murder charge. A mixed reaction so far. Some people saying it was enough, so they wanted more than 20 at least. Others, as you can hear in the distance, perhaps there is some anger. They wanted more, Lester. So we're continuing to get reaction here as this crowd continues to grow. But for now, I'm going to send that back to you, Lester.
All right, Gabe.
All right, so let's recap what we've got here. So Derek Chauvin, 45 years old, convicted in the second and third degree murder of George Floyd, was recommended by the state guidelines for I think it was 12 and a half years. The defense was arguing for no more than that for any number of arguments, and we've already covered those. And the prosecution was trying to get 30 years. He ended up getting 22 and a half, which is roughly splitting the difference. At this point, I don't know. I was asked about parole. I don't know. It depends on the state as to how and when he is up for parole. But that's obviously going to be in contention, and they are clearly going to be attempting an appeal. I would assume they've got grounds for appeal on the fact that one of the jurors lied, and it was not an insignificant lie. The question, the burden is different in every state, but I believe in this case, if the juror lied, the question isn't, did the juror lie? The question is, was the lie sufficient to reasonably expect that it could have changed the outcome of the trial? That's going to be up to a judge to determine. I think it was a serious lie. I think it was an extraordinarily serious lie. And I think he should never have been allowed within 100 miles of that jury. I think Chauvin would have been convicted anyway. So, I mean, it's a tough position. You cannot allow jurors to do what this guy did. It's really, really bad. We have a system based on innocent until proven guilty, and at least one of those jurors assumed guilt going in. I'm really quite convinced of that. You can't do that. But I don't think it would have changed the verdict. So what we do and how we go forward with that, I don't know. My suspicion is, so parole is eligible after 90%. Oh, Jesus. So David is saying that parole is after 90% served. That's going to be a huge chunk of time. He's 45 years old, and he is barred from owning explosives, firearms, or anything like that after he gets out. Obviously, he can never work as a police officer again. My personal belief, it's a very, very large step in the right direction. It's a step, that's all it is. And it ain't a perfect step, but it's a step in the right direction. So, okay, so we were asked to lie. All the jurors were asked how much they'd heard about this case and if they had formed opinions beforehand. They were asked if they'd been in any of the Black Lives Matter protests, if they had been in any of the protests protesting Chauven after what at the time was the killing, because there wasn't a murder conviction. So after Chauven killed the man, had they formed any opinions, and had they been in any protests after that of the killing? One of the jurors said no, he lied. He had been to them. He had worn a Black Lives Matter t-shirt, and I believe the t-shirt, if I recall, said, I can't breathe, which is, of course, a reference to Chauvin's last words. Not Chauvin, sorry, Floyd's last words. That is extraordinarily prejudicial, and that is not someone who and then, you know, pictures of that were blasted all over the internet, and the guy read it, and then it's a bad situation. You cannot be on a jury if you've already made up your mind. I'm sorry, you can't. And I don't care how guilty the person is. Let's convict him. Let's convict him. Let's convict him based on the evidence and based on what's presented at trial. That's the entire point of a jury trial. And if even one of them has formed an opinion beforehand, you're breaking the system. You're breaking the system. Even if he's guilty, you're breaking the system, because every time you allow this, you make it easier in the future for somebody to be tried and convicted in the court of public opinion, which is the one thing this system is trying to avoid. So I think it's actually an extraordinarily serious problem. I did think it would overturn the verdict. It hasn't yet. The judge threw out the objection based on that, but it's absolutely grounds for appeal. We'll see where the appeal goes. Which is another reason you shouldn't do it, because you're breaking the rules and you're setting up for an appeal. If you really think he's guilty, then get off the jury so that he can be convicted the right way and doesn't have grounds for appeal. But at any rate, they have his jury form, and he said no, he hadn't participated in any of the protests. No, he hadn't formed an opinion. And they have him saying, oh yeah, Floyd should, or not Floyd, sorry, Chauvin should go to jail, and have him going to the whole. It's a problem. So, and there's another case that I've been thinking about, and I'm not sure I want to get into, because it's probably one of the darker cases I've ever heard in my life. I think there is a time to discuss it, and it actually does pertain to this. In that case, a man was denied the ability to see his accusers. He was absolutely denied the ability to see his accusers. That's a violation of the Constitution, and he should go free. Having said that, it's one of the most dangerous men ever to walk the face of the earth. I'm not kidding. That's not hyperbole. And he's guilty. He doesn't even deny it. He just wants to get out on a technicality. And the evidence is absolutely overwhelming. But his accusers refused to testify because they were intimidated by him, by the way. Nonetheless, that exception doesn't exist in the Constitution. He has the right. That's a huge problem. And every time you break those rules, and there's no rule that can't be broken sometimes, none. But every time you break a rule, even with a good reason. So I think that's something worth getting into. As Andrew and I actually discussed that a bit on one of our off times coming up. Off time is going to be airing in about an hour. So we have a special guest, progressive liberal, has joined us, and we always enjoy seeing him. And just personally, I'd like to say, Ethan, I hope you are doing well. And it's always good to see you. And my suspicion and sincerest hope is that life has been treating you exactly the way you want it to. So we are pleased to see you here. Thank you for joining us. Everybody, please say hello to Ethan. It has been far too long, and I know everybody in the community misses him, myself included. So what we're going to do is we'll probably be discussing this. Yeah, there are a couple of other things that I did want to. My Discord went out, and I lost a monitor, which is just, oh, it makes life interesting. So, but I did get the notifications on Discord. Thank you, Dorito, and thank you, Titan. Titan wanted to make the show better, so he always tells me when I screw up. Dorito likes to tell me when I screw up, so he always tells me when I screw up, screw the show. But thank you both. We also have in Amazon is going to the Teamsters are unionizing Amazon. This will make it. Amazon is about to become the largest employer in the United States. So, hold on one second, please. So I think that's going to be an interesting Okay, yeah, we have the Chauven thing. That's going to be an interesting development. There were 751 bodies found in an indigenous school in Canada. This is now the second major incident where this has occurred, and a mass grave where it appears that they were slaughtering the children of the indigenous population. And Biden is suing Georgia over election reforms. There's a couple of other suits, election reform suits going on. So, we're going to be optimistic about that. What we have planned for tonight, Overtime, we'll be airing an episode of its new series, season, whatever you want to call it. 5 shows. It's going to be Isandering and I. That's going to be on In Time in about an hour at 5 p.m. We hope you guys will go see that. Because we've split the channel and we now have Overtime on its own channel, we hope you will like and subscribe to this one. We're trying to build this one up. This one's brand new, so it's not monetized, doesn't have any of the privileges of monetization, but we're trying to get there. We're also going to be doing a call-in show tonight, 10 p.m. after dark. We try to keep those light and fun, but I think we're going to talk about some of the more serious news things. But hey, if it goes off into something else, but I think that'll be fun. So I hope you guys will join us. Both of those will be on In Time, the main channel, which should be linked in the description. I'm going to do one more drive-by on the live chat, see if there's anything, any questions that I can help with. But barring that, Maya, wow, it's Ethan. I thought Nick was seeing things again. Really? That happened. Okay, that's happened like half a dozen times, max, in like a 5 or 6 week period. I mean, it's I'm okay. They changed the meds. I'm okay now. Jesus. Some people. All right. So, anyways, to recap, Chauven has gotten 22 and a half years. That is 10 years over the recommended 12 and a half. He will, as I understand it, don't quote me on this, but as I understand it, he'll be up for parole when he has served 90% of that time. He has suggested that there is other information that will come out and give relief to the families. I don't know what that is. He will certainly appeal, and he's going to appeal on the true fact that one of the jurors lied and had almost certainly had already formed their opinion of his guilt before the trial started. As we discussed earlier, I believe in Minnesota, the burden on this isn't that, the burden on this is not whether or not the juror lied, or even if the juror had a preconceived notion, even though they are absolutely not supposed to, and it's a serious problem. The burden is, would it have changed anything? If you had swapped that juror out for someone who was truly impartial, would the verdict have changed? And if the answer to that is no, then there isn't going to be a mistrial. If the answer to that is credibly, it just has to be credibly. You don't have to prove it. It's probably a preponderance or something roundabouts of a preponderance. If you can demonstrate that it's likely that it would have changed the verdict, we start this over again. We start this over again. There's a legal term for when you just have to, just every time you think it's over, you end up starting again. It's called non-sequitis. Just kidding. So thank you all for joining us. And, oh, dear Lord. Oh, yeah, I'm going to kill this stream before the live chat gets any more disrespectful, which is hard to imagine. But at any rate, thank you all for joining us. Like I said, now in about 45 minutes on on youtube.com/InTime Show, we're going to have Overtime with Isandering and I. I like this one. This is a good one. And we've got a few more, Mowdy, myself, Vox, and Joe's Serious Mind, and a few other little surprises. And then we have tonight, 10 p.m., the live call-in show. Call in, give me a hard... No, we'll have a guest, give